Hello everyone, I'm Professor Paul Carrier of the Western Michigan University Thomas M. Cooley Law School, and I'm here to provide some background information regarding Class 8 of Contracts 2, where we delve into the intricacies of the law on assignment and delegation. I had a problem with last presentation to connect the PowerPoint to the actual video recording as you're seeing now, for example. I'll try to fix that, but if you go into Blackboard, you can find the PowerPoint itself that I was working off of as I recorded Class 7's prequel. Okay, so let's go into the intricacies of assignment and delegation. First, remember, there is a pre-existing formed contractual relationship. Full stop. Next question, though, is, now, with regard to that pre-existing contractual relationship, somebody wants to assign the rights to a new person or to delegate the duties to a new person. So you see the two contract aspect here, okay? And again, once you have the assignment or delegation, that is in fact a second contract. So you could put it through third-party beneficiary analysis, but I believe in most cases you never have to take it that deeply, okay? I don't plan to take it that deeply, like I said up front. If you see a third party intended or incidental within the parameters of the first contractual relationship, put it through third-party beneficiary law. If you see a formed contract and later an assignment and or delegation, put it through assignment delegation law, and that's how you lead off, and probably that'll be sufficient, certainly for my purposes on exam. Okay? Now, you have the pre-existing relationship, but somebody wants to change something. They want to assign their right, or they want to delegate their duties under their side of the agreement. And those are two different things. By the way, often they're done at the same time, and it's usually called generically an assignment. For example, if I had contracted, I promised to cut your lawn for the rest of the summer, and we sign an agreement. And then later I get busy and I have a competitor who lives very close to you, and it's easier for the competitor to take care of your lawn. I may assign the contract to him, which would mean I am assigning my right to payment, correct? Because he does it then, he wants to be paid. I would also be delegating my duties so that he and his service does the cutting and not me. So if I say assign the contract, I typically mean that I'm doing both. Make sure you understand, though, that there are those two sides, and if it says assignment, look to see, I could, for example, assign my right to payment because I owe that competitor some money. But I might still have to do the cutting, so I didn't delegate the duties. So keep in mind when you're asking these questions, are they together or are they split? Okay? What are the main issues with regard to assignment and delegation? Well, first, is there a rule against it? Can you freely assign? Because you're making somebody pay another party or perform for another party. Can you delegate? Now you're swapping someone else to perform a service or otherwise perform on a contract, and that other party was not part of the original contract. And the answer is generally no. The law favors assignment, and the law does not disfavor delegation. And I say that because it may be a little bit more difficult to delegate a duty. But ordinarily, there's no general rule against either of them. There are problems, however, that go to the nature of the right or the duty and the party's intention when they entered into the agreement, the original agreement, over which there's an assignment and or delegation. And it might become problematic based on what the parties are thinking. Probably examples are better than anything else to try to explain it, and so I'll try to get to some problems in a minute, but the cases in the case book certainly do that as well. Again, they can be split, right? If I assign my right, I might keep the duty. If I delegate my duty, I may keep the right to payment. What if that other party owes me something? Could I delegate my duty to have that other contractor cut your lawn? But I keep the right to payment. And since I don't do the work and the competitor does, but I get the payment, it's as if that contractor is paying me back for something. So don't forget that these can in fact be split, okay? With regard to an assignment, The big problem is when there is an assignment, can the assignee, the person who's now gaining that right, enforce it in a court of law, right? Can the assignee come out of nowhere from another state and try and collect the money? Or would you come to me and say, contractor carrier, I don't know this person. I know you. You're supposed to cut my lawn, and I want to put the money in your hands and not in someone else's hands. Is there some problem with that aspect that could lead to the requirement of something formal? Does the assignee have to go to court and have a court say, assignee is now the person you pay, not contractor carrier? And if a court says so, you know you can pay that contractor, and then if I'm mad and I want the money later, I have no recourse because we have officialized that assignment. But you probably don't need to go as far as getting a court order. Maybe notice is enough. I tell you, don't pay me, pay the other contractor. And I put it in writing, for example. Wouldn't that be enough? And then you pay the contractor. Then I get mad and I want to sue you anyway. But you have the proof that I told you to pay the contractor. Shouldn't that be enough? And the answer is yes. Okay? Is there a good legal word for it? The right of an assignee to legally assert that right. That's a little bit redundant, but I'm not going to reshoot this video. And the word is probably vesting. Does an assignee who's out there have a vested right such that he or she has the right to legally enforce? And if you pay that person, the original recipient loses his or her right to try and collect a second time. Okay, but now keep in mind if you, for example, pay the contractor without it being done properly, you've paid the one party, but I can sue you on my end. So there may be some requirements on how the assignation takes place, such that you only have to pay once. Okay, so it's relatively easy to assign rights, particularly if it's the payment of money. What if the assignment, however, significantly changes the duty? What if I assign my right to widgets to somebody 8 states away, and for you now to ship the widgets 8 states away is significantly more difficult, significantly more costly? Now, because it's raised the bar on you, maybe then that assignment would not be permitted, okay? Because it adds extra duty, it increases risk, it provides less opportunity to receive payback. If there's some major problem with the assignation, then perhaps it might not be something that the courts will automatically favor. Ordinarily, if it's, for example, just the payment of money, if you pay me or you pay my bank that's a creditor, who cares, right? So long as you're legally protected and only pay once. Not a big deal. Delegation. It's a bit more problematic because often delegation involves a particular person and his or her services, his or her reputation. So if I have someone else cut the lawn, you probably don't care. We're both about equal in our mastery of lawn servicing. Okay? If, however, I delegate the duties to represent you, perhaps that delegatee who's going to now take over the duty is not as good as I am, and you hired me for a reason, and I simply can't turn it over without your permission first. And there would be a case where the nature of the return to you, if delegated, would be significantly impaired. Something would not be right about it. And you're going to see more problems with delegations than with assignments. So if it's someone cutting your lawn, it's probably not a problem to delegate the duty. If it's someone painting your portrait or representing you legally or in a business situation, like a financial advisor, you have trust, you have faith in a particular person, perhaps not. But if you did, I would not be able to delegate that of my own initiative without your permission. And in fact, if I wanted to do that, what would I do? I'd bring you, me, and that other party together, not necessarily in the same room, but what would we do so that I would step away and the other party would be responsible and I'm free now and you've agreed to that other party taking on the duties and probably as well taking on the right to recompense. Begins with an N and rhymes with novation, as you may recall. So that's certainly possible. And that way everyone's done this assignment and or delegation officially with all the parties in agreement, right? That's the novation idea. And with the novation, by the way, and see if you can keep your eye on this ball as you go through. Are there situations where you've allowed a delegation, but you can't sue me? Or is a situation where if that person to whom the duty is delegated does a poor job, you can probably sue that person, but you can still sue me? Keep in mind, if there's a delegation of duty without the novation, I have not been taken off the hook. And so if the thing's not properly done, you come to sue me first, with whom you have privity of contract. And that's perhaps why I would seek a novation. Okay? Let's see now. With regard to some of the cases, and we're nearly done, the first case, Mackey, deals with assignment of contract, so it's rights to be paid, but also the delegation of duties. And just to cut to the chase, please read it carefully and look at the rules and the default and when it's a problem and when it's not a problem. But understand that sometimes the provision of services is so generic, it's not problematic. And so if the person who's supposed to provide services delegates to someone else without permission of the first party, it's probably still not a big deal. And so if it's painting your portrait or representing you in court, that is a big deal, and delegation may require your or the other party's permission. But if it's something simple like sweeping the sidewalk, shoveling the snow, it probably can be delegated, and the other party has no right to complain. Unless it's not done, of course, right? In Herzog, we had a party that made an assignment, and after the assignment, the money was paid, however, not to the assignee, but to other parties. And the assignee has come back now asking, where's my money? You were supposed to pay me, but you paid someone else. In fact, the original person to whom the money would have been owed, who made the assignation, revoked, or at least tried to revoke the assignation. That is, by the way, one of the issues. If there's an assignment out there, is there the right to revoke it as well? Okay? And it could be irrevocable, but typically it's revocable until there is a what? I mentioned the term a little earlier, began with V. Some kind of vesting, so it's not fair for a revocation. That's what you see in Herzog. The assignment was probably made properly. And so payment not to the assignee, but to the original owed party meant that the person making the payment, who gave the money away to the original party wrongfully, is now required to pay twice. Okay, it can go back after the first party, but still you see that the assignation was pretty clear, and so the other party should have been paid, and when not, he or she had a legal right to come back and collect. And notice, right, the notification was part of that aspect. The Dick Broadcasting case, we see a contract that has a no assignment clause without consent. So we've learned that generally you can assign and delegate if it's not particularly problematic. A little bit harder for delegation, by the way. But it's not disallowed unless there's a problem. What if you say, we don't want to do it without permission first? Why not? You can agree to do that contractually. That's not a problem. Question is, if there's a no assignment and or delegation without consent clause, can the person who has the right to exercise that clause do it for any reason, right, or deny for any reason, or must he or she act in good faith? I don't like it because he's got a Ford rather than a Chevy truck, which would not really probably be a good reason. Okay, so that's what Dick Broadcasting comes out with. It adds the duty of good faith, the duty of fair dealing to this exercise of I require you to notify me before you assign and or delegate, and you need my permission first. If you have a clause like that and you say don't say otherwise, it will be subjected to a duty to exercise that right or deny it in good faith. Another issue is gifts. Gifts, when it's not a consideration but a gift, there may be some extra steps that need to be taken so that the gift assignee is able to enforce in court that right. Okay, so just understand that there may be some extra requirements, and you see them, I believe, in a restatement second that's provided in the book. I'll see you in class.